Thank you for staying tuned. Shall we, must we? What does the Constitution say concerning the dissolution of Parliament? The past 1 week has seen a lot of reactions from members of Parliament and non-governmental organizations concerning the advisory opinion by CJ David Maragas. So tonight we are focusing on that, having an interview with Honorable Agostino Neto, who is not only a politician but a constitutional lawyer. Listen in. We're glad you're tuned. We are focusing on the issue of dissolution of Parliament. A week ago, Chief Justice David Maraga gave an advisory opinion to President Uhuru Kenyatta to dissolve Parliament for their failure to enact the two-third gender rule. We are having Honorable Agostino Neto, who is the former Ndiwa MP and also a co-party leader of United Green Movement. Welcome, Honorable Neto.
Thank you very much.
My first question will be, what do you make on the advisory opinion by Chief Justice David Maraga to dissolve Parliament?
I think Maraga was just enforcing the Constitution. It is what the Constitution anticipates in the circumstances. I mean, if you look at the spirit and the letter of the Constitution, the procedure that needs to be followed is well outlined in Article 261 of the Constitution. I mean, it says that, first of all, Parliament had a specific period in which to enact various laws. The two-third gender rule law is one of those ones that was in the general provisions. And the general provisions means that it should have taken 5 years to enact. So particular provisions in that particular Article 261(7), they're mandatory provisions. Discount what other lawyers say, discount what other advocates say. Shall means you must in any other parlance. Of course, you'll have lawyers controverting, and that's why they're lawyers and advocates anyway. They'll controvert as they may please. That shall sometimes mean may, but in this case, shall means must. So, given that Justice Maraga was tarred, he took time before he did that. Indolence on his part does not vitiate or take away the rights of the Kenyan people with regard to the implementation. So granted, he might have taken too long, but I really think that it's something that he must do and he ought to do. So that he did it late, that is neither here nor there. The fact that he has done it. And what he has done is what the Constitution anticipates. And now the person who has the ball is the presidency. So the presidents must also then dissolve Parliament within 21 days, like we've said. And you know, some people ask that there are no express provisions with regard to the number of days that the president shall dissolve Parliament. The Supreme Court has advised that where it's not express in a ruling, where it's not express the number of days, then 14 to 21 days is what is appropriate. So we hope that the president dissolves Parliament or issues a notice to dissolve Parliament in 21 days. If he does not, United Green Movement leadership, we will team up with like-minded people in the Law Society of Kenya and other Kenyans of goodwill, and we shall effect the provisions of Article 1 of the Constitution, which means we'll be taking sovereignty. We'll be exercising sovereignty directly because, House of Parliament stands dissolved, and if the president does not want to dissolve it, we will help him dissolve it.
All right. Some have said that the bad blood between the executive and the judiciary is the reason for this particular opinion coming at this particular time, because some have questioned why didn't Chief Justice David Maraga issue this particular advisory opinion during the 11th Parliament? Why did he decide to issue it during the 12th Parliament?
We've agreed that the timelines for which or when the Chief Justice should be advising Parliament or the President to dissolve Parliament is not constitutionally enshrined. But I am privy to correspondence between the Chief Justice Maraga and the Houses of Parliament. So whereas people say that it took long to issue the advisory, I think there is correspondence, and he has written to Parliament more than 5-6 times, and the response to Parliament actually were attached to his advisory to the president. So yes, it took some time, but I think he also exercised fairness. He exercised fairness by giving the House of Parliament a chance to respond to the issues. But like I said before, the speakers of the Houses of Parliament, the Senate and the National Assembly, I think they were caught pants down. Honestly, in their wildest imaginations, they always thought that constitutional provisions, sometimes some of them are figments of the imagination. They did not anticipate that someone in his normal mind, and in this case, Maragas was in his very normal mind, would use the provisions of Article 261, 267. And in fact, I think it came to them as a shocker, which shows you the level of impunity that both houses of parliament is always exercising. That, they think that parts of the constitution can be implemented as you please. That 267, 2617 of the constitution only becomes useful when it's not against you. You can then say the Houses of Parliament will make law, the Houses of Parliament will oversight, but when it says that the Houses of Parliament shall be dissolved, then they claim the Constitution is inconsistent. I really think that that is what impunity is made of, that you think laws should be applying to other people and not to you. And I really think that if there's anything else Kenyans should help do, or if the president should help do, it's to enforce this particular dissolution of parliament.
All right, there has been a sentiment which we have heard some say that Speaker Justin Muturi of the National Assembly has failed the House as it is, given that he has not given quite a leadership concerning the enactment of this particular two-third gender rule. Do you hold the same opinion?
Everything rises and falls on leadership. Justin Muturi is a leader of the House of Parliament. He is the leader of the National Assembly. God forbid, exit Uhuru Kenyatta, exit William Ruto. Muturi will be the president of Kenya. That's constitutionally provided. So he must understand and appreciate, one, the threshold of his leadership. His threshold as number 3 in command of the country is not ordinary. I mean, give it to Adan Duale. Adan Duale was just leader of majority. But the Speaker of the National Assembly now, if at all Parliament is dissolved, is going to lose his seat as well. I mean, he should have understood and appreciated the magnitude of what non-compliance with the law means. And that is why we have seen Parliament rally before to pass legislation. One, there's been a constitutional amendment with regard to giving more money to marginalized communities. Parliament was marshaled, and there's a way of marshalling Parliament. Speaker Muturi has 349 members of Parliament. To get 233, that means 120 less. I mean, for you not to do that means you're not in charge of your ship. And as the leadership, that's why I said he failed, number one. But number two, he should have explained to Parliament that, one, he was in communication. I've seen, and of course I have colleagues in the House of Parliament. Some of them were grey. Most members of Parliament are out of touch with the reality. The Speaker, Muturi, should have given an express communication to the House of Parliament. Told them, we are in issue of a communication with the Chief Justice with regard to dissolution. How do we do? He should have then marshaled the troops. But if you saw the responses that Honorable Speaker Muturi gave, he starts blaming the cabinet for being non-compliant. He starts blaming the Supreme Court for being non-compliant. He starts blaming the Society of Kenya for being non-compliant. Now, you see now that is what madness is made of. He's being asked why his house is not compliant, not why the LSK or the Supreme Court is not compliant. And for the Supreme Court, it's not up to Justice Maragas to make it compliant. It's up to the presidency. So Speaker Muturi, sitting where he sits, should be in close advisory or giving advice to the president and helping the president comply. All those laws of the House of Parliament that they make, who do they think is going to comply with those laws? What is he presiding over? If at all he cannot comply with the constitutional provisions, why does he think that the House of Parliament can churn out laws? Because what is the role of the House of Parliament? To make legislation. What is the import of making legislation? For people, Kenyans, to comply. So if at all he thinks he is making for us laws, we lesser human beings, Muturi and his crowd are making laws for you little Kenyans to comply. Muturi and his crowd cannot comply to the law. I think that is what impunity is about. And these House of Parliament should be punished, and they should go home.
All right. The move by Justice Weldon Korir to halt the implementation of the two-third gender rule, do you think it will give more time to the House to organize itself, or do you think it might give even President Uhuru Kenyatta more time to think about this particular issue? Because the issue of dissolution of Parliament is something so huge and something that has shaken the nation, so to speak.
That forum is useful, because then it will only help enforce the spirit of Article 2617 of the Constitution to the extent that, you see, the question before Justice Korir is not the validity of the Constitution. And I've spoken to this before. Article 2.3 of the Constitution says that the Constitution of Kenya is a supreme law, and its validity cannot be questioned by anyone. So to the extent that, that Article 2617 is an express provision of the Constitution, you cannot question the validity of that Constitution. You cannot question as to why the Constitution demands that the President shall dissolve Parliament. You see, if it was something else that was a constitutional interpretation in terms of how has the Chief Justice interpreted the Constitution, if that is what was on question, that then would be argued back and forth. But with regard to the fact that the Constitution is expressed, you can't go and start. There are two important articles in the Constitution, in my view. In fact, three. The first one is Article 1, which espouses the supremacy of the people and the sovereignty of the people under Article 1. But the second one is the one that highlights supremacy of the Constitution. Supremacy of the Constitution elevates the Constitution to what in legal parlance is called a Grundnorm, that it is the highest possible law of the land whose validity you cannot question. So whereas when it has an express provision, you can't then question why is it that express. If it says every person shall walk bowed, you can't go and ask why is the Constitution saying like that, because that is what the Constitution is. And the third article, of course, of the Constitution that I think is important is with regard to Article 3, that everyone shall protect, promote, and uphold the Constitution. So that as citizens of Kenya, it is not upon the president only to protect and uphold the Constitution. It's not upon the judiciary only. It is your obligation as a Kenyan. The fact that the Constitution makes you sovereign, that you're the one with the power to choose. Sovereignty is the ability of the people of a country choosing how they want to be ruled or how to be governed. The Kenyan people chose how they wanted to be ruled and to be governed. That once or twice we'll be delegating this power to the Chief Justice in the manner that we have delegated, so that the Chief Justice this time around is spoken on behalf of the Kenyan people. With regard to the president, he should dissolve Parliament because this Parliament is indolent, this Parliament is dysfunctional, this Parliament is incoherent, and it should go home because it has made laws that we do not need. But it has made those laws that are important and the Constitution provided for, they've ignored those laws. So I really think that Honorable Justice Koril's petition is good because it helps test the provision of the Constitution with regard to people activating their rights. But the second thing why I think it is important is because it has given the House of Parliament a moment to do some soul searching. So that even as they go home, because they will, some of them now will have a reality check. Half members of the House of Parliament do not, half of them I'm sure have never read the Constitution. I can bet that. And half of them are even shocked that this kind of provisions of the Constitution exist. And I saw the debate at the House of Parliament the day that the Chief Justice, the day after the Chief Justice issued the orders. Some of them are shocked that this kind of provisions exist. So that shows you that, first of all, half of them will now start reading the Constitution seriously. They will now take, half of them did take the oath of office, swore to protect and uphold the Constitution, because that is the oath of members of Parliament swear to, that we shall uphold and protect the Constitution. Half of them do not know the content of that Constitution. And I'm happy that now it gives them a chance to, those who are studious enough can now open the pages and read. But the third thing, I think they should use this chance to put in place an election framework. They've on their own motion said the IBC is not prepared, or IBC doesn't have money, or IBC doesn't have, it is the time now, these 2 weeks, these 3 weeks, they had better get the IBC ready, so that those who think they want to run for office now have a proper IBC. You don't come back after losing an election to blame IBC.
Quite bold sentiments you have pointed out there. I remember the sitting whereby the members of Parliament, of course, argued out the advisory opinion by Chief Justice David Maraga, and we saw Garissa Township Member of Parliament Aden Duale come out boldly to attack the Chief Justice, saying there will be a constitutional crisis should this particular two-third gender rule, should the advisory opinion by Chief Justice David Maraga not be implemented. And this being two-way or double speak for him, given that in the 11th Parliament, he was the one who brought the motion of the two-third gender rule, which failed due to lack of quorum. What would you say concerning that?
The people need to read the Constitution. And there's a problem of having busybodies, people who just want to talk. Article 2618 of the Constitution says, there shall be an election, there shall be a fresh term of Parliament. That was anticipated. Granted that Article 102 of the Constitution talks about the term of Parliament. That is true, But the same constitution also anticipates that sometimes a parliament can run rogue, like this one has run rogue. And if it runs rogue, it shall be dissolved. And the constitution says if it's dissolved, there will be another election, a fresh election, and that particular election subjects a parliament to fresh terms, which parliament's role is supposed to be very simple: enact the laws that made the other house dissolved. And that particular section says, if the next parliament chooses not to do the law as is anticipated, all the other houses will stand dissolved, and this is a time that the law is enacted. So the constitution is very clear in terms of how it anticipates. The only problem is when lawmakers choose to interpret laws in a manner that is convenient for themselves. They choose to interpret a term of parliament as an election being done for the presidency, for the county assemblies, and for governors. But that constitution also says, and that's why I told you, you cannot challenge the validity of the constitution. The constitution is not inconsistent. The constitution knew that the person who makes laws is not the governor, is not the MCA, is not the president. The person who makes law is the House of Parliament. I know for this kind of constitutional amendment, you know, it could have started its journey either in the Senate or in the National Assembly. I mean, because it's a constitutional amendment. You know, the Constitution provides that, you know, an amendment can rise from either houses. So that is why when the Senate starts talking about the fact that they're compliant in terms of their numbers, it doesn't hold water. Because, I mean, the fact that you are a senator, both of them are houses of parliament. Both had a chance to issue, to originate a constitutional amendment. So the Senate is as guilty as the National Assembly, and I think they both should go home. And if the president does not send them home, we will send them home as the people of Kenya.
There has been the concern that even the women leaders that are in parliament today are not really doing their mandate. You heard Community Member of Parliament Chris Omalwa exchange words with Homa Bay Women Representative Honorable Gladys Wanga, saying that Honorable Wanga was not even in the House during the debate of the Truth General. And therefore it raises the question whereby why should we add more women in power if the ones that are in here currently are not really doing their mandate in terms of representation?
What is the measurement of representation? What is this yardstick that you're putting on women members of parliament that you're not putting on the male members of parliament? I mean, that yardstick, what is it that Chris Omalwa has done that distinguishes him from Gladys Wanga? What is this thing that, you know, you can say he scored 100% and the women legislators scored 50%? I think that's a very, it's a biased lens in terms of evaluating women legislators. The second thing, I think women representatives have been wrongly castigated. I'll give you an example. Gladys Wanga has 8 constituencies in Homa Bay. The amount of money for development funds that she has is 56 million in a year. 56 million to implement activities in 8 constituencies. A typical example is Andiwa MP has 100 million per year. And the impact of what the Honorable Gladys Wanga has done in Homa Bay County with her 56 million a year, I mean, it's measurable. You can go to a few places and put your hands on it. If you ask what the members of parliament in the single constituencies in Homa Bay have done, jokes. So that is why I'm saying that, number one, the yardstick of measuring the performance of women members of parliament versus male members of parliament is wrong. Number two, look at the legislative contributions of ladies, female members of parliament. I mean, I know the Honorable Millie Odhiambo. I know the Honorable Rosa Buyu, women of stamina. Compare the amount of legislative output that the Honorable Millie Odhiambo, for example, has expounded. Google. If you went to the Hansard House of Parliament, I don't think you'd see the amount of competence, the amount of debate that has been espoused by those particular members of Parliament. So let us agree that there's some bad women members of Parliament, just as equally as they are bad members of Parliament. In fact, the male members of Parliament, most of them are worse. So the yardstick in terms of women versus men, I think, doesn't hold water. The third thing with regard to the fact that some women members of parliament were not in the House, so like I heard them say, some of them had gone to New York. That is a failure of the Speaker in case that happened, because the Speaker is the one who approves travels. This is why I told you everything falls on leadership. The Speaker had a chance to say, no travel for the next 2 weeks, put a moratorium, we're not allowing you to travel, because he allows and permits travels. To the extent that he's allowing people to travel when there's such an important motion, just means he's out of touch with the reality. It means he does not give the sort of fair attention of what he does. And then again, look at his misleading remarks. One, the House of Parliament is not being dissolved so that the next one that is the election that is going to happen in December, January, is compliant. No, that's a lie. What is anticipated in December or January when we have the election is that House might not be compliant. It could be, should Kenyans choose to say, now let's elect women and not have the two-third gender. But what is expected of that particular House of Parliament is that they will come and enact law that should be able to provide for the two-third. That is the only thing that is requested. It is not anticipated that that House shall be two-third compliant. No, it is not.
Some have come out to say that for this particular two-third gender rule to be implemented, it should start at the point of party nominations. And therefore, given that you are co-party leader in the United Green Movement Party, do you think really we should deal with the Political Parties Act to enable the implementation of the two-third gender rule? Or do you think it should be at the ballot and not at the party list?
One, Kenya has now a system called a mixed member proportionate, where on the one hand, you have women rep seats, specifically designed for women. But you also have the single member constituencies where the women can run there if they want. If they don't want, they can also choose to be women reps. Now, the best way for us to achieve this particular constitutional threshold with regard to two-third, if Kenya chooses to be a first-past-the-post sort of electoral system, will be to create the number of seats in the constitution that is required. Instead of the 47, make them 94. We have to have special seats, special 94 seats. You can say it's going to be 2 per county, or you can then compound the counties in a manner that gives 94, so that all the counties across the country should be producing 2 women reps, or rearrange so that the total number that you're going to get of women reps is 94 and not 47. That is one option. The second option would be for Kenya to go for a proportional representation system, which would then mean, which is a desired thing, by the way. In a country like Kenya, where people have emotions when it comes to elections, I think a proportional representation system would be the best scenario for Kenya, where we go to the ballot to vote for our parties, United Green Movement, you vote for ANC, or you vote for Ukweli Party, for example. And that way, then, you have assignments of seats. That is the best for purposes of dealing with the provisions of Article 54.2, which talks about persons with disability, which is also going to sort us out with regard to Article 27.8, because then it is possible to have a party list that admits or adheres to that particular principle. Otherwise, there is no two-way. There's been arguments that there's going to be laws under Article 100 of the Constitution to provide for enabling environment. Yes, you need to have an enabling environment, but that enabling environment has to be constitutionally ingrained, either through proportional representation or providing for mixed member proportionate. That is only we can attain the two-third gender rule.
Should President Uhuru Kenyatta dissolve Parliament, do you think you will vie in your constituency?
I am going to run. Whether it's dissolved today, dissolved tomorrow, I will be in the race for the parliamentary seat on the United Green Movement ticket. And the United Green Movement Party, by the way, is fairly unique because for us, we've already internally, in terms of our National Executive Committee, we are already at 50-50. We are an equality party. We are a party that believes in 50% male, 50% women. If you look at the National Executive Council, I have a co-party leader who is female. We have a co-secretary general, which is male and female. So for us as a United Green Movement Party, we're not even worried about those particular constitutional provisions because we appreciate, first of all, that one, Article 27 talks about people being equal. Female and male are equal when it comes to issues of political governance. Nothing makes the woman a lesser human being. Nothing makes the person with disability a lesser human being. Nothing makes the youth a lesser human being. It is why the Constitution talks about equality. And you see, the Constitution says no one should discriminate. So for us, as United Green Movement Party, we've agreed that our office is going to be 50-50. In the only by-election we participated in Kibra, we ran a women candidate. Right now, we're participating in 3 by-elections, one in Sambweni, one in Kilifi, the other one in Wundanyi. We're going to have 2 female candidates and 1 male candidate.
As we conclude, do you really think that President Uhuru Kenyatta will dissolve Parliament, given that the Attorney General currently, Paul Kihara Kariuki, has been accused of misleading the President when it comes to legal advice? So from where you sit, looking at it in both ways, do you see a situation whereby President Uhuru Kenyatta will adhere to the advisory opinion by Chief Justice David Maraga?
You know, for the first time in the history of this country, I think the President doesn't have an option. If he does or if he doesn't, both sides, he's doomed. Because if he doesn't enforce the advisory, he will just be telling the entire world that he doesn't believe in the Constitution. And then it becomes a very difficult question of rule of law and governance. Why should we then obey any law? If the President is the one who's not obeying any law, we'll then choose to drive on the right side of the road, we'll then choose to break curfew laws, we'll then go and open up the jails for all the prisoners, because then the rule of law will have crumbled. The Attorney General, you know, the Office of the Attorney General, created in Article 156, says that the Attorney General should be doing things in the public interest. There is no time in the history of Kenya that a public interest issue has been this huge. It's an issue of equality. You know, some people are belittling this particular issue, and that's why I've said, look, this is beyond women. It's not a women issue. It's an equality issue. The article, the two-third gender rule article, is not in a specific place for women. It is on the article on equality. It simply means me, you, the President, the Speaker. The only thing that we have different is when we breathe our last. But otherwise, Article 27 anticipates that the same treatment that he wants of himself, the same treatment that he wants for you, is the same treatment he should want for me. There is no reason why I should not respect or uphold what the Constitution anticipates. That the Attorney General has been misadvising him, that is their problem. I mean, the Attorney General, I think for the first time knows, and I'm happy he has not issued any advisory issues. And I'm happy that, you know, in these conversations with the speakers of parliament, they discover that this is a very dire situation. Because, you know, where they are right now, the House has bolted. The House has bolted. The only thing the President can do is dissolve Parliament. When he does is what we are not sure about, but that he should dissolve it is the only thing that he can do. And that is the only thing. Why do you think the Constitution starts at Article 1, talking about sovereignty? That Constitution anticipates that sometimes the President can either be indolent. If he's indolent, it says the people can exercise the sovereignty directly. And you know better than I do that, you know, the principal has more authority than the agent. In this particular case, the agent doesn't want, the principal will help him. And 13th of October, we have a rendezvous with the House of Parliament. So as to whether they choose to leave before then, that's their problem. If they choose to stay, we'll help them go home.
All right. Thank you so much for making time and giving us a perspective when it comes to the issue of constitutional matters, in particular, the aspect of dissolution of Parliament. All right, that has been Honorable Agostino Neto, who is former MP of Thiwa constituency and also a co-party leader in United Green Movement Party, saying there is no other way